children.
Mr. Geehy, but before you begin, 3 points really. First of all, I will, for the avoidance of any doubt, make a confidentiality order.
Thank you.
In the terms that I think you've, Council, have seen already.
We've all seen that, thank you.
The second point is we're all very conscious that you've had very little time to prepare for this important appeal. We're grateful for all the efforts that have gone into getting the papers ready, and there is no need for anyone to make any apologies as to the somewhat unconventional presentation of some of the papers.
My Lord, thank you. We've been greatly assisted by this court staff, and we are very grateful.
Good. And the third thing, and possibly the most important, is we are all very conscious of the significance of the Working Party being set up by the Family Justice Council, and no doubt Council will, in their submissions, bear in mind that, well, that's happening, and that we have very much in mind that that's happening.
My Lord, thank you.
Thank you.
My Lord, my Lady. My Lords, in this matter I appear together with Mr. Lebrecht for the appellant. My learned friend, Miss Lucinda Davis, appears together with Sarah Early on behalf of the respondent local authority. The mother is not represented before this court. She has, through her solicitor, filed a letter.
We've seen that letter,
Thank you.
Yes.
Then friend Miss Kate Brannigan of Queen's Counsel, together with Miss Maggie Jones, represent the child through her guardian.
Yes.
My Lord, this is an appeal from a decision of the Court of Appeal handed down on the 9th of February this year, permission being granted by this court on the 15th.
You say the child. I mean, of course, it's all the children. We're concerned particularly with one, but we're concerned with the interests of all the children.
I'm most grateful for that correction, and of course the position of the other children forms a very important part of the considerations which we propose to put before this court.
Yes.
Permission was granted by this court on the 15th of February. My Lord, this case concerns the proper approach to the decision as to whether a child should give oral evidence in care proceedings. The issue we submit gives rise to the need to balance competing interests, and it is the appellant's submission that the Court of Appeal authorities to date have not set the test correctly. My Lord, I do propose to address the question of the work to be done by the Family Justice Council, but if I may, a little later in the submissions I am to make. The background facts to this case are set out in the agreed statement of facts and issues, which is filed before the court, and unless this court at this stage wants any further assistance with regards to those background facts, I don't propose to go to them now. No. When I come to look at the individual circumstances of this case after the legal arguments, then I'll go into a little more detail as to those matters. My Lord, may I begin by endeavouring to set these considerations in the appropriate historical context, which means going back a little way, but I hope not too far into history. And it really means looking at the position in 1988-1989. Concerns about children's evidence in family proceedings were, the documents show, on the political agenda at that stage. In the course of our written submissions, we've referred this court to a number of criminal provisions in order to give some counterbalance and some perspective to the way in which matters have developed within crime and within family proceedings. The Criminal Justice Act of 1988, by virtue of Section 32, brought in live links for children's evidence to be given in criminal proceedings, but put over the issue of recorded evidence for the Pigott report, if I may use that shorthand to describe it. In a parallel process going on at the same time chronologically, cases leading to the Children Act 1989 made clear that hearsay was not admissible in cases concerning children other than in wardship. And in the written documentation and in the bundles, we've produced the case of Re-H Re-K, which was the decision of the Court of Appeal in relation to statutory proceedings, private law proceedings as to children. And that judgment made clear that, as I say, chronologically, in the lead up to the Children Act 1989, the courts decided that hearsay was not admissible in children proceedings. As parallel and similar decision was made in the Bradford case in relation to proceedings in the juvenile court, the venue for care proceedings prior to implementation of the Children Act. And, my Lord, I don't at this stage propose necessarily to go to those two cases. There's nothing that I seek to derive from them in particular, other than just setting us in the historical context of hearsay not being admissible other than in wardship as we move towards the Act of 1989. But what is of interest, we submit, is that those two cases, H and K in particular, led directly to a late amendment to the Children's Bill, adding Section 96 as we now see it. And it might be of assistance if I do take the court at this stage to Section 96. It's in the second of the two authorities bundles, which is file 4 of the court bundles, at tab 25. Section 96 provides, subsection 1, where a child is called as a witness in any civil proceedings, does not, in the opinion of the court, understand the nature of the oath, subsection 2 applies, the child's evidence may be heard by the court if, in its opinion, he understands that it is his duty to speak the truth and he has sufficient understanding to justify his evidence being heard. That reversed the position prior to that section, whereby unsworn evidence of the child could not be received. And as a small, as it were, side marker, we would venture to suggest that the legislature, by passing that subsection, had in mind that the evidence of young children might be received by courts. I don't press that as a point of any particular strength, but it would seem that would have been in the legislature's mind.
Mr. Geeky, I do remember the lunchtime conversation in which this provision was discussed.
I had anticipated that your ladyship might have other background information about this series of events. We've done what we can.
Justified.
Yes, well, when one is looking at the evidence being received unsworn within criminal proceedings, 10 to 12 has been thought generally to be the cut-off point, and so it would seem that that's the direction in which this subsection was going. Subsection 3, the general empowering provision for statutory instruments to be made, which I'll come to in due course, led to the Children Order. There were 3 hearsay orders, but they're in terms of effect much the same, and it's 1993 order which now presides. And subsection 4 can be directed at different proceedings. It's subsection 5 to which I draw particular attention. An order under subsection 3 may in particular provide for the admissibility of statements which are made orally or in a prescribed form, or which are recorded by any prescribed method of recording, and B, may make different provision for different purposes in relation to different descriptions of court, and C is less directly relevant to these submissions. On the face of the subsection, it was specifically envisaged that recorded material might be deployed in family proceedings. And my lords, it's possible to demonstrate that that provision was made specifically with the Pigott report in mind. And I'll come to demonstrate that in just a moment, if I may. But just pausing there at that point in history, we have, before the legislature, issues in relation to children's evidence being considered both in relation to criminal proceedings and family proceedings. And it's the backdrop to these submissions that one can see moving on through the last 25 years or so, that enormous thought, energy and care has been applied to child witnesses in criminal proceedings, but that, we submit, has not been mirrored in family proceedings. Lord, may I take a moment just to look in a little more detail at the Pigott report, which is in the authorities bundle which is open before the court at tab 43. Again, just coming at this from the historical perspective, the use of video links, live links, not recorded evidence, but the use of live links was brought in for the first time, as I've said, by Section 32 of the Criminal Justice Act 1988. We've produced the implementation order. I don't need to go to it. But it's relevant to note that that came into effect in January of 1989. So from January of 1989, the criminal courts first began to receive evidence from children by way of a live video link, children under 14 at that stage. Before that, His Honour Judge Pigott, in June of 1988, was asked to look into the prospect of using recorded evidence. And as we see from the face of the Pigott report, immediately behind tab 43, the committee reported in December of 1989. So the relevance, of course, of that chronology is that the advisory group and the courts had virtually no experience of the impact of live links when they produced this report. The preliminary views of the Pigott report are to be found at paragraph 2.13. Really the section begins with the child's welfare, page 15, paragraph 2.10. But if I may, I'll just go at this stage, just for a view of the preliminary reports of the Pigott Committee at paragraph 2.13 at page 16. We acknowledge that in reporting respects the possibility of giving evidence by live television link from outside the courtroom in trials of violence and sexual offences, which has been made available to the children under the age of 14 by section 32 of the 88 Act, has improved matters. Direct confrontation with the accused can be avoided and the pressures of speaking in public about embarrassing matters reduced. It's too early to make a thorough assessment of this innovation, which has been carefully monitored and evaluated. And in my submission, one has to bear in mind, when one evaluates the balance of the advice of that committee, that that was the state of knowledge in relation to what was clearly an innovation within criminal proceedings that had just got underway. My Lords, the part of the Pigott report which has found expression mostly in the family cases is at paragraph 2.12 on page 15. And that's the part that's quoted in the paragraph that's quoted in full by Lords Justices Wall and Wilson in the Court of Appeal decision in this case, the present case before this court. And it's the one from which, if there's any resonance through the Court of Appeal authorities as to the impact on children of given evidence, it's the source of that sound effect. Paragraph 212, we're satisfied that a majority of children are adversely affected by giving evidence at trials for serious offences under existing circumstances. And, Lords, if I may, the expression under existing circumstances is crucial, because in effect, existing circumstances was the naked presentation of children in the witness box before a judge or jury without any measures to prepare them, protect them, or to assist them after giving evidence. So those were the existing circumstances being considered. And then they go on to the rest of paragraph 212 to summarise the expert evidence being received as to the potential stress and adverse effect upon children of being presented to a court in that circumstance.
Do we know what the source of that evidence was?
Now, yes, the appendix. An appendix which sets out the contributors. It's not an appendix, it's certainly at the back. 74, page 74 of the report.
Yes,
Thank you. Yes, there's a summary there of those who gave evidence. That it's within that collection of people. But I would respectfully submit that when one examines in a little more detail what was said within the section I'm at in the Pigott report, more was being said than just that, a bald statement that children giving evidence will cause them harm. Can I go on to paragraph 215? And the background to 215 really began with the criminal case of Woolwork, which was the case where the Lord Chief Justice said that the evidence of a child aged 5 could not be received. And the concern that there was that the evidence of young children wasn't being received, either because of legal practice or because parents or guardians were not content for their children to go before a court without any form of protection. So if I can just read six lines or so into paragraph 2.15, we also received evidence from police officers and social workers that many hundreds of cases cannot be pursued successfully each year because children seem unlikely to make effective or legally competent witnesses under present circumstances. As a result, some child victims are left with feelings of anger, resentment, frustration, and even guilt, which many experts believe could be to some extent dispelled by legal procedures which enable them to speak fully and freely. And when judged against the progression of Court of Appeal cases in family law as to the effect upon children of giving evidence, that, we respectfully suggest, is a most interesting comment because it shows that under appropriate circumstances, there is the possibility of good effect arising from children being given a voice in proceedings, clearly in criminal proceedings in this context, but it's a comment which could be more widely applied. And at 2.18, just over the page, 5 lines up from the bottom of the page, we also think that the quality of evidence that children give on cross-examination will improve where this takes place in informal surroundings as soon as can practically be arranged. So that's the early recording of the child's evidence, which was then to be used in chief. But again, looking to the fact that despite the unauspicious position as presented in 88-89, the appropriate use of technology and care and consideration could give rise to considerable amelioration for children in giving evidence in proceedings. And again, it's slightly to the side of this case, but just to note that at paragraph 222, at the foot of page 19, the committee recorded that in terms of criminal proceedings, of course, they say, we agree that cross-examination is essential. And again, at 224, at the head of the page, making a similar point, we would be seriously concerned about this matter if it were proposed entirely to excuse the child from cross-examination. So, my lords, just standing where we were at that stage, there was clearly expressed concern about children giving evidence, as was the practice at that time in criminal proceedings, but very much a view that that was something which could be ameliorated. Now, we've produced at a tab in the other authorities bundle. Oh no, it's in the, my lords, we've also, I'll just take the appropriate file. My lord, I hope the court has, in addition to the 4 bundles originally filed, a 5th, which has been, as it were, beginning to collect some additional materials which came in at the end of last week. It was produced by us to this court on Friday with the heading Index Supplementary Material, file 5.
Yes, I think we've got that.
Thank you. The second tab there is a short extract from Hansard, which we don't produce as an aid to a construction, but just as part of the historical development. It might have gone in reverse order. It's either tab 1 or tab 2.
Yeah, we've got it transferred. It's tab 1.
Thank you. With the bold heading, evidence given by or with respect to children, and immediately underneath that one sees it's from House of Commons debates on the 24th of October 1989. Just turning to the second page of that, 10:30 p.m., that was sign of the Times, the Solicitor General introducing a new provision. The third full paragraph, the middle of the page. However, the effect of the recent Court of Appeal decisions in Re H and Re K, and the effect is summarised. So a direct response to that case, which had taken place earlier that year. And then the proposal to remedy the situation in the following paragraph with the 96.3, and in the following paragraph, the last few lines deal with subsections 5 and 6. Will provide for the necessary flexibility. The Lord Chancellor's power will thus be exercisable to provide for the admissibility of statements made orally in writing in any form prescribed by the order or by any means or of any form of recording, for example, audio or videotape. And so that throws the consideration a little wider than is apparent from the section, which simply talks about any form of recording, and demonstrates that video recording was plainly in consideration. And then just on the opposite page, when Mr. Sims responds to the Attorney General, in the second paragraph of his response, he asks the question, what progress is the Pigott Committee making? The relevance of that being that it directly ties the development of criminal and family procedures together as being considered by the legislature at the same time. So what was happening within Pigott was very much before the legislature when dealing with Section 96. And I would suggest that it's legitimate to suppose that given the chronology, which is that this all happened very late in the progress of the Children Bill, we're now in October 1989 and it received royal assent in November 1989, the legislature were considering globally, as it were, the question of how children's evidence might be presented within proceedings, whether criminal or family, and it's legitimate, I suggest, to suppose that they were, as it were, putting over the question of more detailed provision for children until Pigott had reported, but foreshadowing it by way of Section 96(5).
There's an alternative point of view, of course, which is that until re-H, re-K, nobody thought it was a problem in civil proceedings. It was only then that it became clear that it was a problem, and so it was necessary to put something into the Children Bill to cater for that. And although Pigott was going on, it was going on in another part of the forest to do with criminal proceedings, where there'd always been known to be a problem.
Well, Lady, perhaps what I'd suggest is that what we see from re-H and K, it's certainly right that it had been going on before, receiving hearsay evidence, but in a bit, if I may put it this way, a bit of a mishmash. It wasn't quite clear whether it was by consent from individual parties or by lawful authority. So it certainly needs clarification. And I would venture to suggest that it goes a little further because Section 95(6) goes, 6(5) goes a little further because we can see that it was specifically directed towards, in the statute recording, looking at the Solicitor General video recording, and by the response to Pigott being there. So I accept it's to a degree speculative, but if one is trying to unscramble historically...
I'm just going at which angle one's coming from.
Yes.
You're coming from a situation in which, for whatever reason, it had been taken for granted that hearsay was admissible in family proceedings, and then there was a decision of the Court of Appeal holding that it wasn't, and so one had to do something to make sure that it was. And on the other hand, one had got the very clear situation that it was not admissible, and even Livelink was a bit suspect, and certainly recordings were not admissible in criminal proceedings, and so the two were coming from opposite ends of the spectrum. That's all. Pigott was, of course, important in both respects.
Well, no doubt, accepting that proposition, even if that's how things stood in 88, 89, one still then, of course, goes on to look at what had or hadn't happened within each jurisdiction thereafter. And the point remains that whatever might have been intended, the detail of the receipt of children's evidence, as we would submit, been rather left languishing. The order which was passed, as we put in the written submission, was a bare order. It gave the permission, but no further standards guidance at all. And so it's the Court of Appeal that has developed the test that is to be applied, that order having been passed.
Where do we find the order?
The order is in the second authorities bundle, that's 4, at tab 28. I'm taking, that's the 93 order, and the preceding ones are in the preceding tabs.
Do we have the relevant section of the Cleveland report? Because, you see, that was what was going on at the same time, as far as care proceedings were concerned. Pigott was going on as far as criminal proceedings were concerned, but as far as care proceedings were concerned, the question of how you proved cases in care proceedings was given a huge amount of investigation in the Cleveland report. So that was the other part of the background, which is You know, your suggestion that the order was leaving things up in the air, you know, further legislative work to be done, has to be seen against the background of all the other work that was being done and had been done in the Cleveland report, which talks about evidence at considerable length. There's a whole chapter on it.
Lady, I accept that context, of course, and I can only apologise that we haven't put those paragraphs of Cleveland before the court. And I do accept they're, of course, an important part of the historical development. But it's not that I seek to, as it were, make too much of legislative activity or not after the original order was made, but it is, the position remains that it is, as I express it, just a bare order, giving it an empowering provision with no more said about how a court is to consider the receipt of children's evidence. And rising from that has been the need for the Court of Appeal to develop the test. So, my Lords, turning, if I may, to the test as it is now, it doesn't seem to me there's any great degree of dispute between these parties before this court as to what the standard, the test is at the moment. And perhaps I can just go to Miss Brannigan's statement of case before this court, see how she puts it, because I don't think there's any great difference between us. It's file 1, tab 6. Towards the end, paragraph 47, page 18.
I'm sorry, which paragraph?
File 1, tab 6, page 18, paragraph 47, my lord.
You think this is an accurate summary of the current state of the law?
It pretty much mirrors what we've said in our document.
Does, yeah.
If I'm able to agree with Ms Brannigan's, it's perhaps better than taking you to mine. Following lines of principle can be derived from the four principal authorities. Attendance of a child is a matter of judicial discretion. Starting point is it's undesirable the child should give evidence. Particular justification will be required. Although there will be some cases where it's right
I'm
for
sorry,
child...
which paragraph?
I'm so sorry, my lord. Paragraph 47, page 18 of Ms Brannigan's
Thank you.
document. The first 3 bullet points: judicial discretion, starting point, and particular justification. Over the page, although there will be some cases where it's right for a child to give oral evidence, such cases will be rare. The attendance of a reluctant child should not be required, i.e. by virtue of a witness summons, if it would be oppressive so to order. We would add the rider, perhaps, that the attendance of any child should not be required if it's oppressive. And the welfare of the child is a relevant but not paramount consideration. And because one is trying to pick up what the test is from a number of authorities, one could express it slightly differently, but we accept that that encapsulates the key elements of the test as it has been developed by the Court of Appeal.
Are they absolutes? I mean, is the penultimate one an absolute? What happens if that's an absolute? What the proceedings can't go ahead, or they go ahead automatically on the basis of hearsay evidence, however much hearsay would otherwise, for special reasons, be desirable. Sorry, cross-examination would, for special reasons, be desirable.
I don't know that I could suggest that it is absolute, but if one traces the use of the word oppressive through these authorities, it is a very strong consideration described by Lord Justice Wilson as the yardstick of oppression. So he described it as the yardstick by which the case will be decided. And if the trial judge's conclusion is that it would be oppressive, then the child will not be called to give evidence and the case will proceed by way of hearsay without cross-examination.
Yes, but in deciding whether it's oppressive, do you simply look at the effect on the child? I ask that because the third factor, suggests there can be a particular justification for requiring the child to give oral evidence, and so does the last one. The welfare of the child is a relevant but not paramount consideration. In other words, if ultimately there is a discretionary exercise, it must involve some balance between these factors.
It certainly is expressed as requiring a balance, and it may be most sensible if I take the court to the key passages of the key authorities which set this out, because all this is trying to digest points which are made in different ways in different cases, and so one only really gets the full sense of it by looking at those particular passages.
I mean, I think the gist of your case is that the balance is really struck by the second and the fourth factors, namely, in principle it's undesirable, and in principle it's it's rare. And that's, so to speak, the balance is tilted heavily in that direction from the outset.
Yes, we would say that if you have a test which says that the outcome will be rare, then the very test itself is predicting to a degree the outcome, and it cannot therefore be a fair test. It should be neutral. The test itself should be neutral as to outcome. So it is wrong in principle to have a test which express rarity as part of the very formulation. And we make criticism of the second bullet point. There's a starting point. That is, it was characterised by Lord Justice Reimer in the Court of Appeal decision of this case as a presumption, and we certainly submit it has that flavour and that character, that if that is a starting point, if it's a starting point, it's a presumption. And if there were any doubt about that, when one moves on to a particular justification, we submit it, one can probably ask, well, who is to do the justifying? And the answer must be it's for the respondent father to show a particular justification as to why, despite the starting point, despite the expression of rarity, the child should have to give evidence, oral evidence. And so that, again, is an indication that there's a presumption which has got to be rebutted by the father.
Why shouldn't there be a presumption? I mean, as long as it's capable of being rebutted, and as long as the factors which lead to it being rebutted are clearly identified, and I'm not sure they are expressly identified in these 6 bullet points.
Well, we make 2 complaints about that. Firstly, that even if this court would conclude that the test itself is not flawed, it's in principle, it doesn't have sufficient articulation of the particular counterbalancing factors to be borne in mind. And so that is a serious default of itself. And what is entirely absent from the authorities is any specific expression of needing to weigh the competing convention rights of Article. And the child herself will have Article 6 and Article 8 rights. Similarly, the parents, and on the facts of this case and in many, many other cases, the Article 6 and 8 rights of siblings, and I was going to move a little later to say a bit more about siblings, but those are all key competing considerations, and at the very least, they need direct expression with any appropriately formulated test.
Is there something else? As I understand you, Mr. Geekie, you're saying you object to a starting point, if it's elevated to a presumption, at least, and you object to what may or may not be a result being stated as a principle, i.e. rarity could be a result of the application of the right factors, although you wouldn't necessarily accept that, but it's a result, not a principle.
Empirically, it may so turn out.
Yes, exactly. And your further criticism is that what this doesn't do is set out what the relevant factors are
Yes.
to be weighed in the balance.
Yes.
So you've got three
criticisms.
Yes.
Yes. But then going to the...
But sorry, I've got another question before you get into the factors. you point to the Article 6 and Article 8 rights of all the people involved in the proceedings. You know, the complaining child, the other children, the mother, the father, and so on. Is there also sitting in there a public interest in the sense of, or a general interest in the sense of not only these children, not only these families, but other children? Because if one has a state of the law which makes it very difficult for children to complain about what they have suffered, generally, well then that would have implications not only for these children in this family, but for children generally. I mean, were it to be the case, for example, that the expectation was that any child who complained that a parent or somebody close to them had abused them in some way could be summoned to give evidence, and that therefore they had to be warned almost straight away, well, you know, if you're going to tell me this, I shall have to take it further and you might be called to give evidence. If one had that situation, well, then one could easily speculate that it would be a serious deterrent for children making complaints, along with all the other deterrents that there are, and that would be relevant to the balance in any particular case. In other words, there are general interests as well as particular ones. It's taken me a long time to ask you that question, but that's what I'm trying to put to you.
I believe we have a firm answer to that, so I hope it's a satisfactory one. The position your ladyship postulates applies already in relation to a child and criminal proceedings. That if the child is asking or the investigator feels obliged, so to explain, then the child would have to be told, you'll probably have to give oral evidence at a criminal trial. If this gives rise to an allegation of crime, you're likely to have to give criminal evidence. And indeed, the very ABE interview in this case starts off, or has early on in it, a discussion with the child about the fact that she may have to give evidence in a court. So insofar as there is that concern as to the impact upon children generally, it's within the system, and it's difficult to see why an investigator or social worker would be able to, on the child's behalf, filter out what you might have to do within criminal proceedings and what you might have to do within family proceedings. But secondly, and perhaps more importantly, we resist very firmly any suggestion that in any way behind or underlying this appeal or these submissions is a suggestion that children should have to give evidence in family proceedings more often. And the local authority directly say in their statement of case that if this appeal is correct, then it will lead to a presumption that a child should have to give evidence. And we, with the greatest respect, say absolutely not. All we are saying is that when considering this issue, all competing interests should be evaluated from a level starting point, because the competing interests are separately so important that it's wrong to rank them prior to consideration, and it's not convention compliant, we will say, in a way I'll develop in a moment. And so you start from a level basis, and that does not lead to a conclusion that there'll be a presumption that a child should give evidence. What a court will do, what the individual judge will do in the individual case, is look at the circumstances of that child in the context of that case. And I don't want to be tedious about it, but we do stress the importance of looking at the child in the case, because that's certainly what didn't happen in this case.
Mr. Gee, have we got the Camberwell Green case? Somebody mentions it, but I rather think the point my lady raised, I mean, it comes in there, and I think it is a consideration in the case, what the overall impact on the cooperative, on whether children will be cooperative and so forth, you know, the extent to which they are liable to have to give evidence. In that case, it was a special measures case in a criminal context. But I think we did recognise that there is this wider, more general interest in the interests of children generally. I think we actually said, have we got the case?
The case is here.
Oh, well,
yes.
then we'll look at it.
I have to say I can't readily bring to mind the passage your lordship is talking about, but we'll try and identify that and I'll deal with it in due course. I simply can't recall that passage to mind. Lord, I don't think I'm resisting the notion that any decision made could have wider implications, or that needs to be taken into account. I don't think I'm seeking to resist that proposal, but as I understand it, what I'm being asked to address is that, as it were, the message that might come out from any decision made.
So I was trying to put to you, not as well as my lord has put it, the point that there are general considerations in play here as well as individual ones. Not just the considerations in the individual case. The public interest may go wider than that. That's the only point that I was putting.
I don't think I could possibly resist that proposal, that one has to look at the
So the
wider
pass is
implications.
already sold in part because there are going to be criminal proceedings.
In this
Yeah,
case?
in this context.
Well, my lord, certainly in this case, but if one just stands back and posits a future complaint, and we're really, in this regard, we're probably talking about the older child, because the 6-year-old may not be thinking in these terms. But in any event,
Well, you see, this
well, in any,
whatever happens in this case is going to send messages much, much wider than an intelligent, articulate 14-year-old.
yes.
And that was part of the point that I was putting to you. A lot of these cases involve very much younger children, very different circumstances, in which usually the prospect of a prosecution isn't there. But the need to protect not only that child, but other children in the family is very strong.
Well, lady, if one posits the future case, and I accept the proposition about younger children, and even if they're older chronologically with learning disabilities, etc., all that has to be encompassed. But and the child has something to say, and the proposed fear with which I'm grappling is that a responsible investigator, whether it be police or social worker, responsibly has to say something to the child which might inhibit something being said. When one is at that stage, whether or not there'll be criminal proceedings must be an unknown in my submission. So until you've got the account, you can't know whether there can be criminal proceedings. In light of Crown and Barker, what age limits there might be on children being witnesses, I would respectfully submit, is a very open question. So one doesn't know.
But that's changed since the, whichever act it was that completely changed the admissibility requirements for children's evidence in criminal cases.
Yes, but
Well, anybody's evidence in criminal cases.
It's
It's 98.
I mean, I don't want to be too distracted on it, but as an aside, in the light of that case, the prospect of younger children in criminal proceedings would seem to be more open than it might have been before the Crown and Barker. But in any event, going to the positive future investigation, the challenge which I'm seeking to meet is the question, is the position which I'm advancing before this court going to create a situation where a responsible investigator might say something which inhibits the flow of information? If it were to, of course, that would be a maleffect. But I submit that when the investigator, social worker, police or whatever, is first with the child, one can't know whether or not it's going to lead to criminal proceedings, and therefore the possibility of having to give evidence in the future is there, come what may. And I would suggest that what we're proposing in this appeal need not, should not lead to a situation where an investigator needs to say anything different or more threatening to the child about the possibility of having to give evidence. All that's being said here is that when coming to make a decision, a family judge will have to look at all relevant considerations. And I do reiterate, it's no part of these submissions to say that the welfare of the child will not form a very important part of that consideration. So there will be every opportunity for welfare decisions to be taken into account. And it may turn out, looking back 2 or 3 years hence, that empirically the outcome is that it's still a rarity for children to give evidence. If individual judges make decisions such that they consider that the balance is struck in favour of hearsay evidence, then in a sense, in terms of how we present this appeal, so be it. We're not driving at outcomes. Only my submissions in relation to this individual case is slightly different, but that's another point. It's not driving at an outcome whereby more children have to give evidence. So I respectfully accept my lady's suggestion that the court must have a wider look, but I would submit that the outcome in terms of how matters are presented in due course need be no different for children than they are presently, given the arrangements within criminal proceedings.
It's paragraph 39 of my lady's speech, which used to be in Camberwell, and paragraph 70 of mine. There may well be other passages. I'm not suggesting you look at it now, but they're for what it's worth, they are.
Lord, yes, thank you. Well, I'm just pausing to consider the degree to which I ought to take the court to the individual expressions of this test in the authorities as they are. Perhaps I'll just, unless the court specifically invites me so to do now, just hold fire on that and just move on, as it's really been the topic of the exchanges which have just taken place, as to why we say the present test is not convention compliant and therefore must be attended to by this case. So, my Lord, my Lady, the issue in this regard then is the proper approach to dealing with conflicting interests. And our submission is that the proper approach is by way of the process of parallel analysis. And the authority to which we turn to make that submission is the House of Lords decision in Re S, which is in file 3 at tab 16. The
Tab what?
16.
16.
16, 16. The background facts to that are many, many miles from this one. A case of a child having died, the court concerned with surviving siblings and the conflict between the press's Article 10 right to publish and Article 8 privacy of the child. And the key proposition to which we advert is set out in paragraph 17, page 8 of 13, I believe, of the printout which is in the bundles, which is the distillation of the principles from the Campbell Mirror Group case, which is distilled in paragraph 17 to the 4 propositions set out in the last few lines of that paragraph. First, neither article has such precedence over the other. Secondly, where the values under the 2 articles are in conflict, an intense focus on the comparative importance of the specific rights being claimed in the individual case is necessary. Thirdly, the justifications for interfering with or restricting each right must be taken into account. And finally, the proportionality test must be applied to each, for convenience to be called the ultimate balancing test. Our submission is that
This is Lord Stone, isn't it?
yes.
I mean, that's 2 qualified rights, 8 and 10. I mean, you're, for what it's worth, entitled perhaps to make the point that Article 6, on which you rely, is of a rather more absolute character.
My Lord, yes, and that's something to which we've given considerable consideration as to whether or not we should make a claim that an Article 6 right has any greater claim in a balancing exercise. And after consideration, it was our decision, I hope not wrongly, but our decision that it would not be appropriate to seek to argue that a father's Article 6 right in a situation such as this had any prior claim in relation to Article 8 rights. And really the two reasons underlying that decision are, firstly, I believe the most appropriate language is to say that although Article 6 is a non-qualified right, it's not an absolute right. And so if that's the law in relation to Article 6, it begins to make the position difficult to claim a prior position for Article 6. But secondly, the Article 6 rights are in these cases spread across the parties. And because the child witness has her Article 6 rights, and the siblings have their Article 6 rights to a fair hearing. And so in any event, there's going to be a levelling between the parties in relation to their Article 6 rights. And indeed, we've, so far I've just been addressing the situation where one has child witnesses who are parties. One also, of course, has to think about child witnesses who are strangers to the litigation. They will have rights to engage in the litigation.
Are you drawing any distinction between parties and witnesses whose future will be affected by the outcome of the proceedings? Obviously, my colleagues will probably understand that in care proceedings, the children who are the subject of the care proceedings are parties to the proceedings. So clearly their rights are in issue in the proceedings, and the proceedings will be the determination of their civil rights as much as they will be the determination. In fact, in relation to the father in this particular case, he has no civil rights in relation to the particular witness about whom we're talking. His civil rights are in relation to the other children who are the parties to the proceedings. But in other family proceedings, of course, children are not necessarily parties. But would you be drawing any distinction between them?
No distinction at all in terms of the way the test should be framed. In the individual case, if the child is, if I can use the expression, a stranger child, then that might well inform the weight which the trial judge gives to particular factors in that case. It may be, if the child is a stranger child, then depending on the particular facts of that case, one might decide that some facts have less weight in that case than they might if the child was a party. So it's just a question of, it needs to be looked at in the individual case.
I'm sorry, I don't understand what you mean by a stranger child.
Well, was the second of the four cases a stranger child? That was a 12-year-old whose friend, they'd both been abused,
yes,
but the friend was the stepdaughter.
That's right.
It was only the friend's future who was going to be dictated in the care proceeding.
In repeat, that's right. So I'm sorry if it's an inappropriate shorthand, but when I say the stranger child, I simply mean the child who is not a party to the litigation.
Well, I'm sorry, that's what I'm challenging you about.
Yes.
Because in private law proceedings, the child's future may be an issue, even though the child is not a party to the proceedings. A stranger child, I would take to be a child whose future is not an issue in the proceedings, but may have relevant evidence to give. Now, so we've got three different sorts of child. We've got the child who is a true stranger in the sense that her future is not going to be affected by the outcome of these proceedings, or at least not directly affected. There's the child whose future will be affected, but who is not a party to the proceedings, and there's the child whose future is affected, who is a party to the proceedings. We've got those three categories.
Yes.
Are you drawing any distinction between the party, non-party? That's a technicality of family proceedings.
I accept that, and I accept it arises very often. It's not some unusual situation, and it needs to be encompassed. But our argument is in favour of a test which says, if I can just use a shorthand at this stage, all competing claims and rights must be looked at from an even starting point. And trial judges, when considering any of the three positions that my lady posits, will have to look at the position of the individual child or children, which may fulfil different functions in one case, and consider their position within that test. And so if you have a set of care proceedings where there is only one child of the family, only one child involved in any way at all, who is alleging abuse, and so she is the child witness and she is the subject of the proceedings, you won't have to consider any sibling rights, and you will give an intense focus upon her Article 6 and Article 8 rights. If you have a case where the only witness to an event is a child who's not a party to the proceedings, the trial judge, when evaluating the evidence as to whether or not that child should have to give evidence, would have to consider that she has a right to family life and to privacy, so she has Article 8 rights, and would have to evaluate those, but the trial judge wouldn't have to worry about one of the very troubling aspects of these cases, of course, the future impact upon family relations if it is a subject child. And so the range of factors to be considered by the trial judge within the same test may not be so broad or troubling when one is considering a stranger child. So it's what is different, I would submit, is the range of factors to be considered by the trial judge, not the overarching test, which is ultimately the framework within which the judge will decide whether that child in those circumstances should give evidence in that case.
Why are the Article 8 rights of a stranger child engaged at all? Any more than any other witness?
Because of her right to privacy and because of the particularly delicate nature of an inquiry. I'm assuming an allegation of sexual abuse in this exchange because of...
We do have to also think about other types of allegations.
Well, Lady, I accept that,
but let's leave it with the allegation of sexual abuse. Well, wouldn't that be true of anybody, adult or child?
Yes, it may be, but when one is considering a child, you have to, the court has a responsibility to consider that child's welfare in a way that the courts often have to consider welfare for older witnesses who may be learning disabled, and it does crop up in different situations. And those young people who may be over 18 but have learning difficulties equally would need careful and special consideration. And so I submit the child witness, who is not a party to the proceedings, does have Article 8 rights to privacy because of the nature of the allegations and the intrusive nature of the testing of evidence in this sort of case. But depending on the particular facts of the particular case, a judge might come to a different decision if the child were a stranger child than if the child were the only subject child of those proceedings. And so, on all that, I would respectfully submit is consistent with an intense focus on the comparative importance of the specific rights being claimed. That any potential witness who can articulate a claim deserves of that intense focus, and that's what should be undertaken. And their status within the proceedings will be a factor and may or may not influence the decision as to whether or not they should give evidence.
See, it's easy to understand, isn't it, how, as you rightly put it, if we're looking at Article 6, all the children, both the adults, have got Article 6 rights that are engaged in this case. So they're all entitled to a fair hearing in the determination of those rights. And the only question is, what's fair? If you introduce Article 8, that adds a different level of complexity which may vary as between the strangers to the action and the parties to the action. That's the only point I'm putting to you. It's not identical to the straightforward battle between Article 8 and Article 10 that there was in, and that was complicated enough.
Lady,
This isn't necessarily a point against you, it may be a point in your favour.
Well, I accept that proposition entirely. I hope not immediately leaping on the last part of your statement, but expressing the thought that came before it. That may well be. But the challenge that I lay down is to say what reason, by reference to principle or precedent, is there to say that whenever, in whatever conjunction these competing claims are before a court, what reason is there to depart from the res process of parallel analysis? That you, if you're going to be fair, a good old English word, you start in a level way, and this convention law tells us that if you're going to be convention compliant, you start with a level playing field. And
does parallel analysis mean anything more than starting with a level playing field, or has it got a more complicated context than that? I mean, it's your own phrase, is it, or is it taken from one of the?
I have to say, I've tried to isolate where it's actually come from, but it's an expression I've seen often used to express what I understand to be the test in res, that you're parallel, that you look at each competing right from the.
It comes from human rights textbooks, does it?
My lord, I'm afraid I had tried to track down where it had sort of lodged in my mind, and I'm afraid I've not been able to. I don't know. It's not in res. I thought when I went back to res, I thought I'd find it there, and didn't. But it does, I would submit, seem to encapsulate well the res test.
In other words, you look at the intrinsic merits of each of the points without any preconception.
Yes. And my lord, there's a temptation to try and, as an advocate, to try and in some way over-sophisticate or elaborate that, but it's a very simple proposition that the competing interests or rights, however one phrases them, that are engaged in these cases are acutely important and highly sensitive. That the father's right to a fair trial fulfills those criteria, as does the child's right to privacy and the child's welfare considerations. But each of them is so fundamental that we submit there is no warrant to do other than to begin with an even approach. And although a number of conventional authorities are put before this court illustrating different points, there is no warrant we would submit from any of them for anything to say that one interest has a prior claim over another. And we submit that the test as articulated in the development of these cases, which we bring before this court, offend against that principle, because they do have that starting point, the expression of the need for a for a particular justification, and that those to articulate the test in those ways is in conflict. And my lady, that's why I come back to our urgent claim that we're not seeking to make it more or less likely that a child should give evidence. It may well be otherwise. But there is, because of the sensitivity and the importance of the conflicting claims, you have to start from an even point. And and it's set out in our documentation. I perhaps don't need to spend too long on it at this stage, but just picking up on my Lord Brown's point about Article 6 a little further, the Article 6 right is an unqualified but not an absolute right, but the right when one analyses it through the convention case law, is to overall fairness in the proceedings. So the court has to stand well back and look at the overall effect within the proceedings. And it's for that reason that if one looks at the various convention cases on that subject, in some instances hearsay evidence is admissible, in some instances not. It doesn't, the Article 6 right doesn't translate into any necessary result. One has to look at the overall fairness. And that's why we say that one has to measure each of these factors in an even way. And
Well, I find that, I mean, that must stop as soon as you start to measure them, because I think you're saying that as soon as you start to measure them, you in answer to Lord Kerr, you said you look at how strong they are in the particular case, the intrinsic merits in each case, so that the only sense in which they're equal is that on paper they're all there in black and white, but in practice, as soon as one looks at the facts, and as soon as one bears in mind that one's dealing with a child's evidence, you're likely to say, aren't you, that there is, in most, if not all cases, a very strong wish to avoid a child being obtrusively cross-examined, at least in the traditional sense. So that haven't you got, you may say, well, that varies how strong it is according to the child and the age and so on, but nonetheless it is likely to be a factor which is a strong factor in any case.
I, with respect, don't dissent from that altogether, but one has to be, if I may respectfully say so, very careful about how that is expressed, because that proposition can lead to expressing it in a way which is, as it is found in the present authorities, which overrates the importance on that factor.
Well, the present authorities express almost a result. They say that there's a very strong presumption you don't have any cross-examination when you've weighed all the factors, however much you weigh them. But here I'm simply suggesting that this is a factor which you would put into one side of the equation.
Yes, I'd accept that, but and just to illustrate my caution about how it's treated, may I just look at a short passage from the joint judgment of Lord Justice Wilson and Wall in this present case, which is in Bundle 1. That's tab 3A. And it's at paragraph 28, which is, as I understand it, is that the kernel of their Lordship's reasoning in relation to the outcome in this appeal. But the point I wanted to go to in answer to my Lord Mance's point comes at the end of the paragraph. Perhaps I should just go through the paragraph in order and then come to that in just a moment. Paragraph 28. In our view, references in the family jurisprudence to which Mr. Geekie particularly objects, namely the starting point is that the child's oral evidence is undesirable and that it is rare to order it, do no more than represent this court's concern to date, expressed in all four of the authorities, about the emotional health of a child subjected to cross-examination in these circumstances, and its prediction of the likely decisiveness of that feature in striking the balance in most cases. Just pausing there, if I may. In my submission, if one is looking at the cases overall and accepting Ms. Brannigan's summary of the test, one cannot unhitch those comments from the particular justification comment, which comes from Lady Justice Smith in LM. And the first point on that is that if one has a particular justification, I submit that that casts a burden on the respondent. Lord Justices Wall and Wilson then speak about the likely decisiveness of that feature, which is the point my Lord Mance has just touched upon, that the very test includes a prediction as to...
Yes, will you object to that bit of it?
Yes.
Yes.
And in a moment, if I can, I'll just turn to how that works out in practice, because we have some interesting examples of how the test works out in practice, and I'll come to those after dealing with this paragraph. Reading on the court then, in the judgment, deals with the question of whether or not they're per incuriam. I don't go to that part, but picking it up 4 lines from the bottom, the court can hardly be said to have been unaware, for example, of the right of the adult accused by the child to have overall a fair hearing. Indeed, we've already, in effect, described such as being an elementary feature of the central dilemma. That's touches upon the second element of our complaint, which is that the particular features of the test are not sufficiently articulated. We would submit it's not sufficient to infer or assume that all the relevant matters would be in the mind of a trial judge. They need to be set out clearly. And then finally, furthermore, the analysis of the issue through the prism of convention rights as offered to us does not appear to us to generate any significantly different effect from that of existing jurisprudence as we interpret it, founded firmly as it is upon opinion as to what the welfare of the child is likely to demand. Now, I submit that falls on the wrong side of the expression of the test, because it is giving prior ranking to that feature, and it is giving it primacy, if not paramount status. And in the context of the other competing interests, that is not appropriate, and it is not consistent with the Ries approach. And I would respectfully submit this isn't a question of nitpicking over the words. When one looks at the way the test is phrased, it is very, very clearly expressed that welfare has a prior ranking, and that is not appropriate. So, turning to how it works out in practice, because it's always helpful to see the way a collection of Court of Appeal authorities actually lands on the ground when individual judges are dealing with it. May I just take a moment? Firstly, may I go in the large bundle, which I hope is still before the court, bundle 3, the first of the authorities bundle, to the decision in Ries Re W at tab 19. And this is picking up on a point that was made by Lord Justice Rymer in the judgment in the present case. Tab 19 is the report of S&W Re W. To navigate it, I think you have to use the print page numbers at the top right-hand corner of each page. And can I go to 15 out of 17? Lord Justice Wall at paragraph 68, sorry, there are paragraph numbers. Paragraph 68, Lord Justice Wall sets out a lengthy citation from the decision of His Honour Judge Marston, where the trial judge refused to permit the child to give evidence. And Lord Justice Rymer seized on the words which come 5 or 6 lines before the break in that citation as presented on this page. He sees that is the father sees it as grossly unfair. The reality is the position which appertains in 99 out of 100 of these sorts of cases. It is only in very unusual case that a complainant, if I can use that word from criminal law, will give evidence. The child will give evidence. And it then goes on to the door swinging analogy, which again is something I'll come to in a little later. Now, as Lord Justice Rymer says in the Court of Appeal judgment in this case, that's obviously not a scientific test. But taken together with the other matters to which I can take the court, it does give some indication of how this test is working out in practice. A further indication can be found from Her Honour Judge Marshall's decision.
Well, you could say that the history of this case is a fairly clear indication.
Yes, but it's more particularly expressed in the submissions and the judgment of Her Honour Judge Marshall, which is to be found in bundle 1 at tab 8A. And if I can go to paragraph 12 of that judgment. paragraph 12, the local authority relies on the decision of LM. It is submitted by the local authority that the guidance set out therein is clear that it is unusual for a child to give evidence in care proceedings and only in exceptional circumstances. Now, that's clearly a gloss or an addition to that which is to be derived from the authorities, but one finds the local authorities submitting that what is required is exceptional circumstances. At paragraph 13, one finds the Guardian's submissions summarised, and at the foot of the page, picking up the last words, it is suggested that this case is not exceptional. So the Guardian is submitting that what is required is the hunt for an exceptional case before permitting the child to give evidence, and that lodges with the judge such that it's to be found at the very end of her judgment. Page 10 of that judgment, paragraph 15k. Although this will undoubtedly be a difficult case, given the nature of the allegations in the background, on balance, I'm not persuaded that the circumstances are sufficiently difficult or exceptional to justify interfering with the local authority's decision not to call C to give evidence. So, my lord, my lady, taking together His Honour Judge Marston 99% and these comments about exceptional, although, of course, I can't pretend it's scientific, it does give this court a sense of how this works out in practice.
I thought we also had Lord Justice Wall and or Lord Justice Wilson saying they'd only ever come across it once in their entire professional career.
My lord, that was the next, if I can say so, evidence that I was going to produce. Both Lord Justices, Lord Justice Wilson in LM, para 56, if anyone wants the reference, makes that point, and Lord Justice Wall in Re W at para 55, that they had never had a child give evidence before them. And so that gives one a sense of how this is working out in practice.
I can't help thinking that there are some similarities to the arguments and reasoning in the case of Norris, which we handed down judgment in. I don't know whether anyone's looked at it. It's a very different field, but the complaint there was about the use of the word exceptional circumstances, and we in fact put a slight gloss on it and said that what one should be looking at was the exceptional consequences, but it's in the context of sending someone abroad, extraditing them in order to stand trial, so it's rather different from this.
I regret, my lord, I'm not familiar with the authority.
Well,
but
there's no particular reason why you should be, Mr. Geeky. It was about extradition, but it was to some extent behind my earlier comment to you, in that that, of course, is about the difference between the effect upon extradition of Article 8 rights and the balance between the general value of adhering to extradition requests as against the particular effects on this father. There had been some reference to exceptionality in earlier case law. Yes. So to some extent, it had motivated my earlier question. So yes. It's interesting that we're both thinking the same.
Well, lady, thank you.
Have a look at it. It's not probably
You've
too
got
burdensome.
Yes. Yes.
But without being able to cross-refer to that case directly, I do submit that it is of value to this court to see how the test expressed in that way falls out on the ground. And
of course, there's a prior thing, isn't there, Mr. Geeky? In practice, Lord Justice Wilson and Lord Justice Wall, I think both of whom gave up first instance judging in care proceedings slightly after the time when I did. They've never had a child give evidence. I think I never had a child give evidence, but nobody ever asked me. I don't remember anybody ever asking. So you've got a further point, haven't you? Again, it may be for you or it may be against you or whatever, that because nobody expects such requests to be granted, people don't ask.
Well, if I grasp that too readily, it may come back to hit me with your latest earlier point in relation to the global effect of these cases. So, cautioning myself, and subject to that, it is a point, yes, but if the perception is that it has to be exceptional, then and the starting point is the child won't give evidence, then indeed nobody asks, and that may not be doing justice to some cases. We touched very briefly on the door swings both ways argument. Can I just deal with that, because in my submission it is important. Something to which Lord Justice Rymer drew particular attention, but the door swings both ways argument is encapsulated in the suggestion that if a child is not called, there is a concomitant weakening of the local authority case. Adopting, if I may, Lord Justice Rymer's approach to it, that is, on reflection, a highly unsatisfactory situation in this type of litigation. We're not engaged in straightforward adversarial civil litigation. We're engaged, of course, with the court being charged with a decision as to the welfare of the child. So if the door swings, one swing of the door is that the judge has to reject an allegation that is possibly true because the judge has not heard from the child, then the system may well be failing. It's not satisfactory. There's a system intended to settle disputes between individuals, but rather to promote the welfare of children, may come back with the wrong decision for lack of evidence which could have been put before the court. And so to say that, well, the door swings both ways, we respectfully submit it is not good enough because it abandons the court's child protection responsibility. And if I may, I'll simply adopt Lord Justice Rymer's summary of it to say that it's a profoundly unsatisfactory outcome.
Where does he, I know he said it, I'm just trying, where does he say it?
It's at...
No, I've got it loose, but what paragraph?
my Lord, I'll just take you to it. Uh, 52. It's dealt with partly there, and I think it's elsewhere as well. And it's at 52 that he also deals with the what he analyses the straightforward situation and the unsatisfactory nature of that.
But I mean, surely the deeper complaint is that it's very unfortunate if it swings either way. In other words, it's unfortunate if the judge has to reject, even though it may be true, because it's only hearsay, but equally, if it goes the other way, and the judge actually convicts because there hasn't been cross-examination, I mean, that's unfortunate that way too.
Well, my Lord...
Convict.
Sorry?
Convict.
Convict in the sense that in care proceedings, the order made is the order that supposes that the father is guilty of what he's accused of.
And Lord, that takes one to another very worrying aspect of the presentation of the arrangements as they are, which is, well, perhaps we ought to articulate it better in the written documents, but the present arrangements have a hidden bias in them. The present emphasis is in favour of not hearing from the child, and in my submission, that creates a hidden bias in favour of accepting the hearsay account of the child. Once the decision is made in an individual case not to receive oral evidence, I submit that decision gives rise to a pressure on the court to accept the child's account. Now, the reason for saying that is that unless the account is self-evidently flawed, a judge who rejects an account without hearing from the child risks a serious injustice to that child. One only need to think about the case of a competent teenager with the social worker coming back afterwards to say the judge didn't accept your account, and the child saying, but the judge didn't hear me. And so, if a case is to proceed on the basis that there is an even chance that the court will reject the account, if the child doesn't give evidence, the court needs to give the most serious consideration to the consequences of doing so without hearing from the child. And if one looks at the dilemma from that perspective, it does, in my submission, create for a judge a pressure or a hidden bias in favour of accepting the account of the child once the decision is made not to hear from that child, because of the risk of grave injustice to that child if we reject her account without having heard from her. And so I've earlier resisted the proposition that this is a submission globally, which is to have more children give evidence, and I would look to this to support that, to say that the tensions and sensitivities of this are such that underlying it there is the risk of actually doing harm to the child, perhaps certainly unintentionally, but the emphasis on not hearing from the child, risking harm to that child, or risking a bias in favour of
But
accepting
there are risks anyway. I mean, doesn't all this simply underline what all counsel very well aware of, huge responsibilities that fall on family judges who have to decide these things?
My Lord, I accept that entirely, but if the arrangements are such that the expectation is the child doesn't give evidence, it's such an important decision in the setting up of a case, in the case management, that if the present system can be seen to not be doing justice and to have inherent risks, then in the context of the anxieties your Lordship articulates, it is a negative contribution to helping judges sort that out. And I accept the context your Lordship articulates, but the judges are entitled to have a test which gives them full flexibility, a full discretion to make sure all relevant matters are taken into account and that there is no bias one way or t'other.
Can you just help me? I'm afraid this is a question born of my ignorance. Looking at the relevant section in the Act, a care order may be made if the court satisfied the child concerned is suffering or likely to suffer significant harm. How does that work in practice when a judge is assessing the evidence? Does the judge make positive findings one way or the other as to whether the evidence is accepted, or is it possible for a judge to say the evidence may be true and therefore I'm satisfied that the child is likely to suffer significant harm?
In wardship, the judge would have been able to take the latter course.
Yes,
but
not in a care order.
Not in care
But actually,
proceedings.
possibly find on the balance of probability that there is the story is true and there is therefore likely to be further harm.
Yes. Looking backwards, you have to be satisfied on the balance of probability an event either did or didn't happen.
Yes.
Assessment of future risk has to be on the basis of proven events, not speculation. I hope that in a couple of
Yes,
sentences.
that's beautifully put, Mr. Geeky, as I would
And
expect.
the local authority has set out in the clearest possible terms the findings of fact which it is seeking, and it's going to be the family judge's duty to make findings on those allegations.
Yes, and just to flesh out the structure of the proceedings in a little more detail, in just a moment, the convention often is that where there are hotly disputed facts, there will be a split hearing. The court will decide the contested facts first on a fact-finding mission before coming later to consider the welfare outcome for the child in the light of those findings and applying the welfare checklist. So this is set up as a split hearing, the fact-finding hearing. Did these things happen or not? And when the judge has made that determination, if the local authority have approved a case, then the judge in due course will go on to look at the welfare considerations and ask what the future for these children should be, all of them, in the light of those facts as found, and any other assessments that might have taken place on the basis of those facts as found.
Of course, if the stark situation that you have put to my lord only really arises where your only basis for thinking that there is an appreciable risk of harm to children in the future is because a particular event has happened in the past. That's the situation in which you have to have found on the balance of probabilities that that event took place in order to justify your prediction.
Yes.
And that goes back to the case of Re-H in 1996.
Yes.
Recently reaffirmed in this
I believe so.
court, yes.
And yes, there's a further sophistication is that one may be looking at simply findings of fact as to whether or not this thing happened, and then going on to say, in the light of that, is the threshold, as my Lord just read it out, satisfied? Or one might be doing both together. It depends upon the range of facts before the court.
Could I just mention something else, just so that it's at the forefront of everybody's mind as we're considering these very difficult issues? And that is that it's not entirely right to say that the judge has not heard from the child. We're not talking hearsay evidence as in a witness statement given by the child, or as in other people's accounts of what the child has said to them. Most of the time. I mean, some of the time one is. But in most of these cases, we are talking about a video recorded interview done under the Achieving Best Evidence guidelines, which everybody is able to watch. And if it's done properly, it's done either jointly or individually by a police officer and a social worker who have been trained to do this in such a way as not to put leading questions to the child, not to put words into their mouths, not to, to counteract any suggestion that they are playing upon the suggestibility of a child witness. In other words, taking a great deal more care than is normally taken in an ordinary examination in chief of an adult witness. As a general proposition. So we're mostly talking about, although it's technically hearsay, it is actually a direct recording of what the child has said in an interview of that nature to a police officer and or social worker. Am I not right, Mr.
My lady, I accept
That's
that entirely.
Mostly what we're talking about.
I accept that entirely. And where I've had a shorthand of not hearing from the child, I, of course,
yes.
accept
Well,
that.
well,
But
it's
I
only
mean,
that you and I have done loads of these cases. My colleagues have done, well, possibly Lord Kerr may have done, but my colleagues have not. So it's important to know what it is we're talking about.
Yes.
We're not talking about not having heard from the child. We're talking about not having heard directly from the child and not having given those representing the people who may feel affected by what the child has said a direct opportunity of cross-examination.
yes.
That's what we're talking about.
And the judge has, it happened, already relied on the video in paragraph 15I of her judgment.
Yes.
As one of her reasons.
Yes. And when a judge looks at all the issues as to whether or not the child should give evidence or not, that's very much an aspect which the judge can consider. And indeed, in some cases, as it happens not in this one, the judge may have expert evidence to guide him or her as to the potential liability of that recorded statement. And so there's additional evidence which can be taken into account. And one additional point, if I may, on the ABE interview, which is relevant, as your ladyship has summarised, it is, of course, done in that highly professional way, giving the chance the child to speak and not challenging the child. But therein is its own difficulty, which it is not a challenging account. And so, although I accept all that your ladyship said, one has to recall that it is very much a free account with no challenge of any sort whatsoever.
I was going to ask that. I mean, at the time, firstly, what sort of time in advance of the trial are these video interviews recorded? And at that time, will there in practice have been any knowledge of the likely response of people such as the stepfather in this case, and any opportunity for that likely response to be fed into the questioning in any way?
The ethos is get it done as soon as possible. This child was video interviewed on the day that she made her complaint at school. And so that is the guidance, to get it done as soon as possible, so it captures the child's account as fresh as possible. And so, firstly, there is no opportunity at all to know how any person might respond to it, because it's the first capturing of that evidence. And indeed, under the guidance of the ABE interview procedure, for an interviewer to seek to challenge or to put another person's account would be regarded as wholly wrong. that is not the purpose. The purpose is to have the child give the account. And, my Lord, that summary of how these things happen does impact, come back into the point that my lady and my Lord Brown were making about the wider impact of these cases, that's how they often start. And that is, in my submission, when one looks at it from that perspective, gives some reassurance that the anxiety which the court rightly raises with me is not likely to apply in practice, because these interviews are almost inevitably led by the police. That's the starting point.
On a slightly oblique issue to that point, is it open to the judge to prescribe how cross-examination will be conducted if she decides that the child should give evidence?
I would respectfully submit the answer to that must be overwhelmingly yes.
To the extent of requiring counsel to submit questions in advance?
Of course, the evidence base for my answer to Your Lordship's question is limited
of
for
course.
obvious reasons. But where I personally have seen children give evidence, and I've experience of very learning disabled, just past children giving evidence, 19, 20, 21, but functioning at a much younger level. And certainly, in one case I have in mind in that regard, the judge made absolutely clear to counsel in advance that in cross-examination she would take a pretty dim view of leading and would be likely to discount questions which were, or answers which arose from leading questions. So counsel was, in a sense, free to put the questions he or she chose, but knowing that given the limitations of the witness, the judge would receive them in a particular way. How far particular judges might go, I think it's difficult to say.
But those are forensic issues. I was more concerned about a judge who was anxious to ensure that the child was protected as far as possible. What measures could the judge take to ensure that the child was not oppressed during cross-examination?
During the cross-examination of itself, I would anticipate that the judge would readily and immediately intervene if counsel were acting in a way which the judge regarded as oppressive. And there's greater facility to do this when, of course, one has the child on a live link, because the judge can get quite a lot across to counsel without a word being said, and I certainly have experience of that. If you've got everyone's either on the TV, but there's eye contact and gesture contact between counsel and the judge, that can do quite a lot to moderate cross-examination, which needs a little moderating. Or judges, I would submit, would be entitled to take more direct steps to limit counsel. The idea of questions in advance, personally, I've certainly never encountered, and one can see that might give rise to further considerations. But in my submission, there is plenty of opportunity for that to be done, and I would suggest it's proper to bear in mind. I think I don't seek to make a comparison with criminal law, because my criminal law experience in practice is somewhat distant now. But I think one can fairly claim that advocates in family proceedings are accustomed to questioning witnesses who are very limited for a variety of reasons. Often parents who are very limited, young adults who are very limited. And so there is a body of experience which could be brought to bear in the task when it does happen. As it does already, as Ms Brannigan noted in the footnote to her document.
Sorry, I was just coming back to the question of when the ABE interview was, because I think that's quite important, and because the child made more than one complaint at school, but it's set out very clearly in paragraph 7 of Ms Brannigan's skeleton, identifies when that took place.
Well, there are now two interviews. The 18th, Mr Liebrecht will correct me if I got the wrong date, the 18th of June 2009, the child made a complaint at school. She'd been saying things to friends and some parents for some time, but she said something to a teacher on the 18th of June, and that ABE interview took place that day.
Yes.
Then the chronology which Ms Brannigan extends is the account we have from Ms Brannigan is that when Charlotte, if I can call her by that pseudonym, not her real name, when Charlotte was told the outcome of the Court of Appeal proceedings, which of course she was rightly took place, she on that day made further comments to the social worker, which were then the subject of a further ABE interview on the 13th of January. And that chronology is of passing interest in illustrating my Lord Savile Mance's earlier questions about these processes. The first interview was conducted by the police in the joint investigation, them looking at a crime, social workers also present and taking part from their perspective. The second interview, the police had indicated that they didn't wish further to investigate, so that was considered by Judge Marshall, and she invited the local authority to arrange what's called a single agency interview with Just Social Services undertaking that interview. So we have an illustration, in fact, of two different types of interview taking place in this case.
But am I right in thinking that the content of the second interview was more concerned with allegations not only about Charlotte herself, but also her mother and her half-siblings?
Very much so.
Yeah.
Yes.
And it was physical abuse other than sexual abuse?
Yes. Yes.
I'm just wondering, why wasn't there an ABE interview back in, whatever it was, June 09, when the, not June 09, June 08, when the first allegation was made?
Because I believe what happened is when Charlotte said something at school, when the police went into, I can't remember if it was police or social workers, but certainly when she was first spoken to, she immediately retracted what she was reported to have said. So there was the beginning of that chain of events was a friend showing a text message, Charlotte then being spoken to, and her not putting forward a complaint herself. I speculate to a small degree, but I would imagine in that situation the police felt, well, if she's not saying anything, there's nothing for us to interview her about. In fact, because they saw her in school that day and she said, no, my friend's got it wrong, it's all a misunderstanding, they then the next day took a police witness statement from her where she disavowed that which had been said by her friends, and then later was interviewed herself as a suspect for having wasted police time, where she admitted that she had, where she made a statement to the effect that she had lied in giving.
Well, it doesn't matter very much. I mean, I think you're rather muddling up two events, because then there was another occasion when she said that the girl had misunderstood what she'd said.
There was a further such event, or a prior one. There were two.
Just following up Lord Kerr's point, would there be anything to be said for a situation where not only were the general lines of wished-for examination disclosed to the judge in advance, but the judge actually put the questioning? I mean, I've seen procedures on the continent where it is standard for the questioning to be done by the judge, and very rare that anything remains which, at the end, which counsel wish to ask separately. In Germany, they're certainly entitled to, but I'm not sure about other jurisdictions. I mean, is that, certainly in France also, the judge does a lot of the questioning. Is there anything to be said for that, bearing in mind that an experienced judge would know, be firstly, familiar to the witness, and secondly, would know how to put the things unobtrusively?
Well, my lord, firstly, I personally have never come across that, and I would anticipate that most of the family judges in front of whom I appear would be reluctant to step into the arena in that way. I may be proved wrong, but certainly in cases where I've heard children give evidence, that's not been the case, and I would be surprised if it were. But one part of the written presentation we've made to this court is the parallel view, not analysis, parallel view of criminal proceedings and the special measures that are available to children in criminal proceedings, and one of those measures is the use of intermediaries. Now, I have no personal experience of that, but I understand that that does take place and that intermediaries are used within criminal proceedings. I can't speak with any authority about it, but as I understand it, you would have a person who had specific training to assist in the questioning of a witness, who was appointed by the court, I believe, and would be fulfil some of those functions which my Lord raises, and there would be, in my submission, no reason in principle why that could not be available in a family case.
It's only because we think in traditional common law adversarial process terms that we're not used to the idea that the court may act as an inquisitor. But of course, if we're thinking in terms of what Article 6 of the European Convention requires, we have to think how it would appear to a continental judge. And a continental judge would probably be quite surprised to think that it wouldn't be the judge's responsibility to take the questioning further if there seemed to be things that had not been properly explored in the, assuming there is an ABE interview, of course there isn't always, but assuming that.
Lady, yes. In principle, I wouldn't dissent from that.
There is a study of the intermediaries measure, a preliminary study of the intermediaries measure, which I can dig out for you all, which is very encouraging.
Yes. Well, anecdotally, I've heard good reports in relation to criminal proceedings, but I can't really urge that any further than that simple comment. My Lord, may I turn to make such submissions as I have in relation to matters being put before this court now and the fact that the Family Justice Council are undertaking a task?
Yes, please.
The report as to what's to happen is extremely short, and that simply reflects the newness of it. There's a very short letter from the Family Justice Council which simply says that Lord Justice Thorpe is setting up a multidisciplinary committee as proposed by Lord Justices Wall and Wilson, and it has its first meeting on the 16th of March. So who is to take part, what the remit will be, we can't know, other than that we have a number of questions asked by the Court of Appeal in this case. So the issue, it seems respectfully to me to be, is how should this court today approach this appellant's case in the light of the fact that that is to be going on? My Lord, can I come at that question by looking at a short passage from the judgment of Lord Justice Wall in the Re W case, to which I've already referred briefly already. It's in file 3, the first of the authorities bundle, at tab 19. Paragraph 57. Paragraph 57, Lord Justice Wall, well, in that section of his judgment, he is, paragraph 54, he sets out his view at that stage that the state of the law was generally unsatisfactory. That's the end of paragraph 54. Paragraph 55 is the paragraph where he deals with the point about he never having had a child witness before him. Paragraph 57, Lord Justice Wall gives his views on the what has or hasn't happened under Piggott, and in the middle of that paragraph says this: if the law is to be changed, and if children are either to be compelled to give oral evidence in court or to be excused from doing so, it must be for Parliament to make that change. With the greatest respect and deference to Lord Justice Wall, I would respectfully submit that the proposition underlying that sentence is where we are already. We are already in a situation where judges have to decide whether children are to be compelled to give oral evidence or to be excused from doing so.
I'm sorry,
Paragraph 57. I hope I've taken you to the right place.
Yes.
Re-W,
yes,
tab
I see.
19.
It's halfway down, paragraph 57.
Yes, thank you.
Bang in the middle of the paragraph. Whether children are to be compelled to give evidence or to be excused from doing so is where we are. We have the hearsay order. Judges have to make that decision. And although I've not accepted all that Lord Justice Wilson has previously said about the test, it will be recalled in Re P, he says that the application must be approached on its merits and without preconceptions. So judges are already tasked with precisely that, so that there is we would submit nothing in that sense to go before Parliament.
Yes, what would Parliament say?
Well,
Parliament have already said hearsay is admissible.
yes, well, that's my submission entirely. That it's classically the role of the courts to, as they have done, set out the way in which that power should be, or that power should be exercised.
Surely what you're really complaining of is the third and fourth lines. No doubt the argument is that where the defendant's liberty is at stake, he must have the right to test the evidence by cross-examination, irrespective of the harm that may be caused thereby. I mean, that may be true in criminal proceedings, but nobody suggests it's true here.
Quite so, yes.
Yeah.
Yes.
I think when he says it's for Parliament to make the change, he's talking about the criminal law. Is he about criminal evidence? If he's switched over to family law, it's not easy to see at which point precisely he's done so.
Basically, you're accepting there's a discretion and saying that
Yes.
it's got slanted.
Maybe I've misunderstood it, but I hadn't seen it in that context.
I think he's in care proceedings, as the next sentence rather suggests.
Yes.
Yeah.
Well,
Yes. Well, then maybe I've had misapprehended what that was saying. But in any event, what I was seeking to do is to take two ends of the possible spectrum. This appeal raises a particular point. Is this the right point in time and the right venue? Do we need legislation? Or at the other end of the spectrum, is it a contribution from the Family Justice Council? The Family Justice Council may provide background evidence, and I don't say that dismissively at all, background evidence against which these applications can be considered by judges. And it may be very valuable background evidence. So when a judge has to consider a particular case, we would submit the judge should have evidence particular to that child as to the likely effect upon that child, evidence about all the other competing interests to be considered. And it may be very valuable for that judge to set that evidence in the context of whatever the Family Justice Council is able to contribute. And it undoubtedly would be an extremely valuable contribution to the evidential evaluation that judge must take. But, my Lord, looking on from today into the immediate future, any cases that arise for decision before the Family Justice Council reports, the courts will need to know what tests to apply. And going beyond that, in any cases that follow any report from the Family Justice Council, the courts will need to know what tests to apply.
Do we know whether they've been asked to report by a particular date?
I don't know any more than is in that brief note. I came to my attention that it had been set up. It seemed to me urgent that this court should know something about it. I asked to be given as much information as I could at the time, and that letter was produced as a result of that inquiry. So I'm afraid I can't, other than the 16th of March, I can't assist at all. And that information is fresh as of, I think, about Thursday last week. I mean, I could overnight make inquiry as to whether the personnel are yet confirmed, but I was told at that stage that they, although people have been invited, not all had yet accepted, etc. So it's very fresh.
Certainly.
But, Lords, therefore, in a nutshell, there is, I don't suggest otherwise, much that can be contributed to the evidential assessment that is to be made, but none of that will, or does, avoid the need for the test to be considered. And if we're in this appeal wrong in our submissions, then there is a test. If there's any virtue in our submissions, then this court can say what the test should be upon a proper legal analysis and applying domestic and conventional law. And that is the test which will guide judges when they have to make these decisions in cases to come, either side of any report from the Family Justice Council.
Well, whatever the Family Justice Council does, they can't tell anybody what the test is.
I agree.
They might be able to say something about what it should be, but they can't say what it is. That's your point, isn't it?
It is quintessentially a task for this court. My Lord, would that be a convenient moment, or?
Yes, I'd make it 2 minutes too, but if that's a convenient moment, Mr. Gige, then we will look forward to hearing you again at 2 o'clock.
Thank you.